Good evening, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. Tonight is our Tuesday night live. I apologize for coming on a little late, but that's what happens when you're in trial and you have to drive across town to get back to the Crime Talk studios to make sure that you are here to answer questions. Tuesday night is the night that we answer questions for our subscribers, and boy, there is a lot to talk about, as always, which is always interesting when it comes to the true crime genre, so to speak, because there is always something going on, for sure. Let's just do a quick recap. For those who are not familiar with this channel, my name is Scott Reisch. This is Crime Talk. We started it a couple years ago because we were frustrated that what people saw on TV or described on TV is not what actually took place in a courtroom. And so part of our job here, we like to do, is to make sure that we explain what's being done and really why it's being done. Because frankly, most people don't know why, in fact, it is being done. So our job here is to explain it. Nothing brings me greater satisfaction than when somebody says, "Hey, Scott, I've been watching your channel, watching your shows, and, I used to hate everything about the defense side. They have more rights than, the defendants have more rights than the victims or the everyday people." And then we've tried to explain, well, those rights come from the United States Constitution, and that, they're that's where the basis for criminal law comes from in all cases. And so that brings me a lot of joy and happiness. Or when I can explain a question. The other night there was somebody asked me a question. I just happened to glance at my phone and said, what's the difference between a demonstrative exhibit and an exhibit that's actually admitted into evidence? Well, the demonstrative exhibit is something that is not admitted into evidence. It's something usually that looks like it. The real exhibit, but maybe they don't have the right one. They, think it was fired from a particular type of firearm, but they never recovered the firearm. So they bring in that piece of evidence or demonstrative evidence to show what the firearm, for example, may look like. That's all it is, but it doesn't get submitted to the jury because it's not related necessarily to the case. So that's what we, we like it when we actually explain the legal system and the process to people, and people say, "Hey, Scott, I get it. I appreciate the legal system. May not always agree with you. That's okay. Number one rule, you don't have to agree with the host to watch the channel, okay? If you disagree, let us know. We'll take you first. We'll answer your questions first. Maybe you'll change my mind. But what we do is try to explain the law, try to explain cases that are going on, what the attorneys are doing, both the prosecution and the defense, and hopefully provides a little more clarity for what is going on. And if you're a Patreon member, we actually send you this trial guide where it has all the rules of evidence. And if you listen to a trial, you'll see that these are the objections that people that attorneys make in court, and explains why they're doing it and explains it. So if you're a Patreon member, if you haven't got that yet, let us know. We'll send it to you as well. All right. Obviously, a lot going on today. And I'm going to be completely honest with you because that's what I have no reason to not be honest with our subscribers. I've been in trial all day. I've been seating a jury. So I did not get to watch the Dereck Chauvin trial today. Kind of frustrating, but I was, sometimes like the day before, I was able to listen to most of it because I was in a car going back and forth to a hearing and doing some trial prep. But I wasn't able to watch that today, so I'm, kind of getting up to speed on that. But I didn't have time to do it all day because literally we were seating a jury all day long. Anyway, we have that case we can talk about. We have the Daunte Wright case. Man, and I tell you, the officer who shot and killed this 20-year-old kid has resigned. That's a good thing. The officer who can't recognize a taser from their firearm. Like, are you kidding me? I've never been a police officer, okay, but I've had, duty belts on. And tasers, I mean, just from the appearance of them, don't look and feel like a firearm. And basically the officer's like, ooh, oops, sorry about that. Now, Daunte Wright, had he just complied and not tried to get away, he'd probably be here today. One of the things that is always frustrating, particularly when you get clients that get charged with resisting or something to that effect, they always want to say, well, it was an unlawful stop, so I was going to fight it. Well, you have to fight it in court. No matter, now I understand Mr. Daunte Wright was pulled over for a traffic infraction, okay? And I'll be honest with you. Come on, really, people? Do police officers really have nothing better to do than pull people over for traffic infractions? Like, come on. Violent crime is up just about everywhere. But yet, we need to do traffic enforcement. I mean, I get it. You got to follow the rules. We all follow the rules. Why shouldn't everybody else follow the rules? But don't the police have a little something better to do? It's kind of like, the situation where everything is criminalized. Every one of us could probably be charged with some sort of a crime if, the police followed you for a day or so. They could pull you over. The reality of it is like, really? Traffic infractions? They don't do traffic infractions. They do it for either A, money, or two, to make contact with somebody because they think that they look suspicious, right? They're in the neighborhood. Oh, didn't quite use that turn signal 300 feet before they executed that turn. My God, we have to pull them over now. Otherwise, it's a gateway crime. Not using your turn signal today could be, failure to stay in a single lane tomorrow. You never know where it could lead. Next thing you know, you're robbing banks. It just shows you everything is criminalized. It's just ridiculous. Maybe people wouldn't have so much damn contact with the police, and the police wouldn't have so much contact with people that, for lack of a better term, mind their own business if everything wasn't so criminalized. All right? Now, but the reality is, Mr. Wright was pulled over. He had warrants. When you have a warrant, guess what? Even if you disagree with why they pulled you over, you're going to jail. You don't have a right to resist. You don't have a right to flee and run away. Wrong, wrong, wrong. However, violating a traffic stop or even trying to get away is not an excuse to be shot and killed. And if anybody disagrees with me on that, you're first up. He did not deserve to be shot and killed. I don't think that was the officer's intent. Her intent was to taser him. This officer had 26 years of experience. This officer, now former officer, Kim Potter. But she mistakenly mistook her gun for the taser. Excuse me. I don't understand how that happens, but things happen, I guess. But it's rather somewhat shocking to me that could actually take place. But here's your free legal advice of the day. If you believe that the police are arresting you unlawfully, you don't get to run. You have to take the arrest, so to speak, and you challenge it in court. But you don't get to run. And he's one of those cases. Do you charge the police officer? Didn't really do it. Do you charge him with negligent homicide or reckless? I mean, geez. The officer was literally like, oh my God, I shot him. And the other officer on the body cam video was like I think the words were, oh God, or oh no, or something to that effect. It's not good. A lot of fault to go around. But I think most people would agree, even if Mr. Wright was going to run away, they knew who he was. I mean, how far do you think he's going to get? I mean, I just don't get it. I just don't get it why the police had to do that. Now, in the Chauvin matter, the defense has started presenting their case. Now, remember, the defense never has to present any evidence. The defense never has to prove the defendant innocent in any way. The burden always rests with the prosecution. That burden never, ever shifts to the defense. All right? One thing the prosecution can never do, even like in closing statement, say, well, the defense could have called this witness. Oh, no. That's burden shifting. Completely not permitted in a criminal case whatsoever. So looks like they called an use of force expert by the name of Barry Brode. He basically said that, Mr. Floyd was becoming more compliant as time went on. At one point, he apparently wasn't compliant. And then they talked about use of force. And obviously, he's a defense witness. He's stating that the use of force was appropriate. I mean, we would expect that. That's the defense witness. Obviously, we heard from several witnesses on the prosecution side saying that everything that Dereck Chauvin did was wrong, even though the police department who came in and said he did everything wrong, the same people that trained him. So a little bit of hypocrisy. I don't know. When the police chiefs are up there testifying, saying this is why I fired him, use of force, blah, blah, blah. Everybody knows police chiefs, when you get to that level, you are a political machine. You're a political hack, right? You're going to do what you have to do to keep city council happy, the mayor happy. You're basically at odds with the police unions at any point. Most police chiefs don't have a reputation for defending their duty line officers. And there's always this tension between the police unions and the chief of police. So, I don't know if I give that much stuff. Obviously, the big question in the Chauvin case is going to be the doctors. But, we'll see. The defense, like I said, I didn't get to see it today, but I think Eric Nelson's been doing a great job. I did ask both Julie and Frank, and they said, I think, correct me if I'm wrong, you thought it was a good day for the defense, correct?
Yes.
Don't come for me.
Okay, only Frank's saying that. And then, the prosecution called Nicole McKenzie to testify to the defense concerning the department's excited delirium training. Normally prosecutors, and I'm just saying, all the prosecutors in the Chauvin case, obviously very experienced, right? I think I've counted 5 prosecutors that have been doing the case. 5. They've clearly broken up their witnesses. You're the use of force attorney. You're the medical attorney. You're the voir dire attorney. They got like 4 or 5 attorneys on that side. Eric Nelson is one guy, and it looks like he probably has either an associate or a paralegal back there trying to help him. But for lack of a better term, is doing everything on his own. Welcome to, I always tell people when it says, the people of the state of, whether it's Colorado or Minnesota or the United States government, that's what it means. All of the resources that come with the state against you. They've got 5 attorneys in the courtroom, probably another 5 outside of the courtroom, working on issues, prepping witnesses, coordinating everything that's taking place. And Eric Nelson's like one guy. So that's a clear example of that. Let's see here. Minneapolis police officer Peter Chang testifies in trial of Dereck Chauvin. He described the crowd that watched George Floyd's arrest as loud and aggressive. I mean, it's going to be. I mean, it's an interesting case. What I hope is that truly it goes all week. Since I'm in trial, I won't be able to probably watch it. I'll have to go home and watch the replay on CrimeTalk and do that in the evening hours while I'm not sleeping, preparing for trial. But I will, in fact, do that. Wow, look at all the questions that just went through. Wow. Let's see here. Teaches high school. Never disobeyed the police. I gave her my attorney's card and told her to shut up and follow the orders. Yeah, shut up, follow the orders. I mean, seriously, more people get into more trouble. I mean, I've seen simple little, whether you like the police, whether you completely respect the police, all you have to do is just treat everybody with dignity and respect. And that goes for everybody involved. If the police would treat people with dignity and respect, people wouldn't give them attitude. Even if the cop's giving you attitude, I know it sucks, all right? And I'm not exactly one that likes to keep my mouth shut, but that is neither the time nor the place to, tell the cop that, he's incompetent, he's arresting you illegally, blah, blah, blah. I've had many a cop tell, this is on the street, this is where, I own the street. Okay, fine. All the more reason, wait until you get to my backyard, which is the courtroom, and we'll deal with it then, where you have to answer my questions and nobody cares if you're wearing a badge or anything along those lines. So, we'll go from there. Let's see. The state has the burden of proof. They need more hands. Yeah, but it also means they have a hell of a lot more resources and money. I mean, that's what it comes down to. It's resources. I mean, can you imagine the weight of the state, particularly in a high-profile case where they said, spare no expense, do whatever it takes, get a victory. They're pulling out all the stops. Nelson looked tired the other day. He was losing his voice the other day as well, and then it seemed like it kind of came back. But, yeah, I mean, here we are now in week 3. He's probably been going nonstop for about the last 12 weeks. And he's handled every witness. He's handled every motion. He has got to be exhausted. That's just the way it is. Don't the people deserve a well-funded prosecution? Absolutely. I'm just telling you, that's just the reality of it. The state has the resources. The defendant does not. My understanding is it's the Police Union Protective Association, basically their insurance defense fund, so to speak, paying for Chauvin's defense. Do you really think that most reasonable people, most everyday person said, hey, you need to basically pay an attorney to prepare for the better part of a year, then spend, we're in court he's in court 8 hours a day, but he probably has a couple of hours per night, a minimum. So let's just say, 12 hours a day. Assume he's making $300-400 an hour. Maybe it's less because it's like a insurance plan, so to speak. But let's just say $300. If you had to go hire an attorney, $300 an hour, you're paying him, say, for 12 hours a day. That's $3,600 a day times 20 days. That's $72,000, not including support staff, copies. That's just court. Most people could not come up with that money. Some people would say that's not fair. Well, that's why you also have the public defender, but you have to be in custody normally to do that. So I'm a realist. I get it. The state has all the resources. And that's a good thing. The state should have a well-funded defense. I get that. But it also just kind of shows you that when the state comes after you, look out. They're coming for you. Kimberly, yeah, Nelson needs some help. I wish he had. I mean, I think it's a paralegal behind him that always seems to be on the computer every time, they glance over there. But the reality of it is, I mean, you would think he would have, at least another one or two attorneys trying to help him. Hopefully they're doing behind the scene. But he's doing a great job. He really is. And I like good lawyering. I like to watch good lawyers. And if people I think are not doing well, I'll tell them, I'm not perfect. We've all made mistakes. But the amount of work and everything that Nelson's done, I mean, the other day, I'm telling you, he hit it out of the park. Now, the day before was a little rough. I think it was Thursday was a little rough. But Friday, he ended really, really well. Let's see here. I'm not sure if this is to me or somebody else. The "do you agree" statement that Mr. Nelson uses for cross, is that a common cross tactic or just Mr. Nelson's MO? Good question, Carrie. So, and a lot of people, I saw a lot of people the other day in the comments saying, oh my God, another hypothetical. Okay. When you're cross-examining expert witnesses, you can ask hypotheticals. You don't normally get to ask hypotheticals to an eye and ear witness, but you can ask hypothetical questions to the experts. And that's what they do. And when Mr. Nelson says, do you agree with the statement that, there's a general proposition that he knows that the expert will more than likely have to agree with it. That a police officer's situation is always changing. You have to reevaluate the methods that you're using, the standards you're using, the force that you're using as the situation develops. He knows the answers to that, and he knows that they're going to have to give it to them. And he has got it out of the expert witnesses. Even the guy yesterday, the professor from South Carolina, my God, did anybody happen to notice, or was it just me? He couldn't just answer yes or no. He would always qualify it. Well, under these circumstances, but yes, I agree with you what you're saying. Like, just answer the question. Like, just answer it. The prosecution, you're their witness, they're going to get redirect, so you get to answer it. You look like you're being evasive. Just answer the question, right? Experts always think that. And Nelson's been doing a great job with that. I mean, there's some stuff, let's face it. There's an old adage, particularly when it comes to expert witnesses, where they say, when you wrestle with a pig, you're only going to get muddy, referring to the expert witness. The expert witness is always going to know more than the attorney, unless maybe, let's say if they're a doctor, unless maybe the attorney is a doctor. There are a few of them out there. But that's why you hire experts to either A, come testify, or B, tell you what questions to ask. And that is so important in cases particularly like this. I had a case years ago, we worked on it, it was a 35C, where the attorney thought that it was a homicide case. And the attorney thought, well, I interviewed the coroner and she gave me a textbook to read and said, kind of this was it. So I cross-examined on that, really didn't talk to an expert. So when the doctor got up and started saying things, you don't know what you don't know, he had no clue that what she was saying, according to my expert, any first-year medical student would know that's not the truth. Now, you would hope the medical examiner would, be intellectually honest and just tell the facts within a reasonable degree, come to conclusions in regards to her opinions within a reasonable degree of scientific certainty, and not just make crap up. But that's what you do. But how do you know if you don't know? That's why you have to have an expert in a case like this. And I'm sure those experts have helped Nelson draft questions to those experts, or he has his own experts' reports and he knows what they're going to say. And so they're challenging it. They're creating that question of fact. And that's ultimately for the jury to decide, just as it relates, to any legal case. The jury is the judge of facts. That's right. When, jurors stand up and leave the courtroom, so do all the parties, right? They come in, the jurors come in, everybody stands up out of respect because they're a judge, just like you do the same thing with a judge. They're the judge of facts. They're going to decide, is Chauvin factually and legally responsible for the death of George Floyd or not? Did he die of asphyxia or did he die of a heart attack because of the drugs that he was on, his life history, et cetera, et cetera? It's not uncommon, particularly, just to get back to the question, it's not uncommon when you talk to experts, would you agree with? It's very common on cross-examination. It would be a fair statement to say this. You would agree with me about this. Very common. And remember, direct examination, you have to ask who, what, when, where, why questions. Non-leading. On the cross-examination, usually it's the defense, you could ask leading questions. You can say, isn't it so George Floyd had, I think it was 13 or 11 nanogram of fentanyl in his system? Yes, he had 13, nanograms in there. You told them the answer. The answer is yes or no. And most attorneys will try to do a good cross-examination where you can get the witnesses saying yes, yes, yes. And if they say no to something and you want to say yes, you have something to impeach them. It's kind of like training a dog where you whack them on the nose. I know you're not supposed to whack them on the nose, but it's just an example, right? Don't do that. You whack them on the nose. They don't do it. They do it again, whack them on the nose. By the end of the time, they're saying yes. I had a case once where it was so beautiful. It was yes, yes, yes. He'd say no. It's like, oh, really? Well, let's take a look at this. You said this, and so the answer is yes, yes. By the end of it, he was saying yes to things that he had never said, but he was agreeing with it because he believed, he knew that I had something to back it up with. So you have to train a witness sometimes. All right, let's ask a question. Should the jury have been sequestered, especially given the events with the police that took place this week? Most courts, and I think most jurors, do not want to be sequestered. I mean, it's not like you're going to the beach. You're going to a courthouse, to a courtroom, and usually not a night. It's not like you're staying at the, the Four Seasons or the Ritz or something like that. You're probably staying at the Holiday Inn. A very nice accommodations indeed. I've stayed at many Holiday Inn. I like the express ones, to be honest with you. They're not bad. But, would you rather spend 3 weeks in your own bed? They've been admonished not to watch the news. I don't think anybody expected the Dante Wright matter to happen, but that's reality. The judge didn't want to probe into it, and now we know that it's really not the same situation in the sense that now we have an officer that, shoots somebody by accident because they're taser, for goodness sakes. The jury is going to be sequestered once they are given the case. The case is ultimately given to them at the end of closing arguments. The judge doesn't want to do that over the weekend because, people have plans. Is that a good thing or a bad thing? Maybe let them work all weekend. Why not? You think the attorneys are going to be thinking about it all weekend? Gee, what are we doing? So they're going to do it, probably closings on Monday. I don't know. I've never had a jury sequestered. I've had high profile cases where it's in the newspaper front page every day kind of thing, but I've never had a jury sequestered. You just tell the jurors you can't look at the news. I think the judge is making the right call. In fact, I really like this judge. I think he has good judicial temperament. He is, from what I can tell, being very fair to both sides. There's some trials or, some judges you're just like, really, judge? Really? Yeah. It's not even fair, so to speak. But I think this judge has done very, very, very good job. Who knows? Maybe the Court of Appeals, if there's a conviction, will determine, they did something wrong. But what I think he's doing a good job from what I've seen. I'm not going to say I've watched every minute of it, but what I've seen over the course of the pretrial and trial, I'm very impressed with Judge Cahill. Scott, why didn't we hear the gunshot on the Potter's body cam? Her partner didn't seem to hear it either. I'm not sure. The body cam that I listened to, it almost sounded like they maybe like bleeped it or something. I don't know. That question's from Ashley. Thank you for that. But yeah, I do not know why that was the case. Let's go up here. Thank you, Cheyenne Monk. Shout out from Cheyenne, Wyoming. Leonard Apodaca. All right. Well, I'm not sure that's for me or Cheyenne Monk, but thanks for watching, Leonard. Appreciate it. Appreciate the old super chat. And as always, we don't ask for super chats, but as you can see, or maybe you can't, they get highlighted really big, at least on my screen. And so it makes me obviously try to do that because somebody took the effort to do that. I'll try to get to all the questions. I wish I could. Let's see here. Other questions here. Conduit of Light. She believes that this will be a hung jury. I think we can assume that they are aiming for. Yeah, I mean, the problem with a hung jury is you have to do it again. And let me tell you who does not like hung juries even less than the prosecutors or the court. The defense, right? The defense, yes, you have to disclose stuff. You have to disclose expert reports, but you had your kind of one bite at the apple, so to speak, and you've let the world know what it is. I don't like hung juries. I'm trying to think of a case where I've ever, when you hung a jury, usually they come back. I guess I could think of one case. We tried it 3 times. And the fourth, my client disappeared. So he didn't quite make it back for that. But so yeah, let's just, maybe he made a run for the border and never been heard from again. So yeah, I mean, it happens. And I remember it because he was supposed to have a hold on him, and for some reason it got lifted, unbeknownst to anybody. Next thing you know, they're like, he's bonded out. I'm like, I didn't know he was bonded out. Really? And I literally thought the district attorney's head was going to explode. And, the bonds person didn't know. He's like, people show up, they paid the money, I got him out. So it's what can you, it happens. But yeah, normally second or, retrials, never good. So the murder in second degree, we had a question here. Let me just get this question here. How does definition of second degree murder in Minnesota compare to other states? Seems to require less than in my state. Yeah, so normally second degree murder is basically the knowing killing of another person, but it wasn't an after deliberation type of thing. So the Minnesota statute here, murder in the second degree, they have intentional to murder, drive-by shooting, obviously not applicable. But subdivision 2, unintentional murder. Whoever does either of the following is guilty of unintentional murder in the second degree and may be sentenced to imprisonment for not more than 40 years. This is straight from the statute. 1, this is not really applicable, but I'm going to read it. Causes the death of a human being without intent to affect the death of any person while committing or attempting to commit a felony offense other than the criminal sexual conduct in the first or second degree with force or violence or by a drive-by shooting. Or paragraph B, causes the death of a human being without intent to affect the death of any person. So basically saying he didn't intentionally intend to do it. While intentionally inflicting or attempting to inflict bodily harm upon the victim. When the perpetrator is restrained under an order for protection and the victim is a person designated to receive protection under that order. As used in this clause, order for protection, that's setting pretrial conditions, criminal sentencing, juvenile courts, blah, 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 blah. That's not right. Unintentional murder, that's murder in the second degree, Minnesota. Cause of the attempt to cause, while attempting, inflicting, or attempting to inflict bodily person when the perpetrator is restrained on the order for protection, and the victim is a person designated to receive protection under that order. And that's from the Office of the Reviser of Statutes. That's not the one that murder in the first degree. Yes. Okay. Yeah, that's the second degree statute. That just doesn't seem right to me. I'm not sure how they're going to get that whatsoever. But normally in most jurisdictions, murder in the second degree, first degree murder is usually after deliberation or some sort of extreme indifference. Second degree murder is that you knowingly caused the death of another person, but it wasn't although intentional, it wasn't after deliberation. I don't see that happening here. The third degree, the statute for third degree is what they have charged as well. When I read that seemed much more appropriate, and that was the one that the judge originally threw out. So it's third. Alrighty. Third degree. Whoever without intent to effect the death of any person causes the death of another person by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life is guilty of murder in the third degree and may be sentenced to imprisonment for not more than 25 years. Paragraph B, whoever, without intent to cause death, proximately caused the death of a human being by directly or indirectly unlawfully selling, giving away, bartering, delivering, exchanging, distributing, or administering a controlled substance classified in Schedule 1 or 2 is guilty of murder in the third degree and may be sentenced to imprisonment not more than 25 years. The third degree murder is paragraph A. It's in fact here basically the eminently dangerous, depraved mind. Now, Mr. Hall, the person who maybe allegedly gave the drugs to Mr. Floyd, would be charged under the third degree murder under paragraph B. Now, wouldn't it be ironic that if the prosecution convicts Dereck Chauvin and then they go after Mr. Hall, the Maurice Hall, to charge him with the death of George Floyd, they would basically have to say that he caused the death, and they wouldn't say Chauvin caused the death. They could do that. Be completely inconsistent theories, little hypocritical, but they could legally and lawfully do that. Cheyenne Monk, thanks for always keeping it real and honest. Well, I appreciate that. That's the only way to do it. Real and honest, because what other way is there to do it? I mean, seriously. Let's see. Trying to keep up to see the truth. Let's see here. Palma Dr. Martin Tobin's testimony will be very challenging to overcome. I don't think they even put a dent in it today. I wasn't able to see that, but I don't think there was any evidence regarding pulmonologists today. Correct me if I'm wrong. No. Yeah, I'm being told that that's not the case. They're only first day into it. And, it wouldn't, I would bet, let me bet, I will bet you $1. And this is my theory on the case. The Dereck Chauvin prosecution, although very, very skilled attorneys, they're doing what prosecutors do. They over-try cases. they look and say, oh my gosh, they're bringing an expert. Oh my, we better bring in an expert. Oh, the defense has brought another expert. We got to bring in that expert. Well, they got one, but we'll get him with some with better credentials. Okay? They over-try it, trying to overthink what the defense is going to do. Well, maybe they're going to get an expert in this, right? Like all these people didn't pop out of the woodwork and say, it's my opinion that he died of asphyxia, right? We know the one lady, I can't remember her name off the top of my head, that used to be the coroner boss that testified, who said she basically volunteered, her services. They reached out to her, but they're hired guns, whether they're on the prosecution side or the defense guy. The only guy that really, the only guy that's not getting paid his just his normal wage. I know the one lady was donating her time and the other guy was only getting $1,200 a day, was the coroner. And he's the guy that works with these prosecutors every day, that they trust to the bitter end on every other case until this one. And then they have to go and talk to all these other people. It's all these other experts. And the state sometimes over tries the case. I mean, how many use of force experts did they need? How about just one really good one, right? The general rule is if you're going to have a witness, I'd rather have one incredible, amazing, jump up and down witness than 4 lame witnesses, right? Juries get bored with it. Hell, even the court was entertaining not allowing the last use of force expert from the prosecution to testify because like, what is going to be new? And they said, well, it's a different model for analyzing use of force. No, it wasn't. It was the same stuff. But every time those witnesses get up there, the more they talk, the more they have an opportunity to slip up and agree with the defense. I know some people don't like little sidetracks, little anecdotal stories, but let me tell you, I had a case once. It was a simple case. I think the offer sucked, so he said, "Fine, let's go to trial." It was a fight, and of all things, I think it was a quinceañera, right? When a girl turns 15, they have a big party, big thing. And there's a lot of drinking that goes on at these apparently. Although I was invited to one recently from a client, very fancy card, I might add. I didn't get the invitation in time. But apparently they're quite party, good food, lots of adult beverages being consumed. Anyway, at this particular case, a fight broke out. Not exactly sure why, but a fight broke out. Needless to say, then the police are called. And my client gets charged. He hires me. We go to court. Like, listen, if that's your offer, it's a one-day trial. Bring it on. Let's go do this thing. And instead of just calling one witness and said, yeah, that's the guy that, hit the woman and left it at that, my client promptly would have been convicted by a jury of his peers. But the prosecution overcharged it. And over-prosecuted it. So instead of just bringing in one witness, she brought in 5 witnesses. And by the end of those 5 witnesses, nobody knew what the hell had taken place. It was so confusing that the district attorney got up in closing statements and said, so maybe we don't know exactly what took place. Ooh. Yeah. I literally remember the judge looking over at me, making eye contact with me. Can't remember if there was a little wink in the eye kind of thing, but it was something like that. And I literally got up at the end of her closing and said, ladies and gentlemen, if they don't know what happened, how do they expect you to know what happened? That is reasonable doubt. Okay? And that's kind of like what's I see happening maybe in the Chauvin matter. I'm not rooting for any side. I really don't care. I don't have a dog in the fight. But with Chauvin matters, they're bringing in so many people. And, okay, you can bring in the best of the best, but it doesn't change the facts. The guy had fentanyl in his system. He had methamphetamine. and you got the state's own doctor that they didn't want to have to call to say that he died of a heart attack with contributing factors, i.e. drugs, clogged arteries, and basically poor lifestyle choices throughout his life that led to this. That's not unreasonable to believe. And I'm sure the defense is going to call people and say, we agree with that opinion, right? I don't know. We'll have to wait and see. I mean, I really, really hope. But it's a very interesting case. And I don't think, some people already made up their minds. Okay. And that's why, you wouldn't be a juror, because you have to agree to not make up your mind until you hear all the evidence. If you're looking at it as it relates to something like that. But it's going to be interesting. It's going to be interesting. But prosecutors can over-try their case. Courtney Robb, exactly. Jurors don't become aficionados overnight. That's right. But if they had watched it, they would know. But let's hope the jury is giving everyone the presumption of innocence and holding everything there. Rita, yep, you're exactly correct, Scott. Okay. Don't know exactly what, but I'll take that. Because sometimes it gets a little old being told, I don't know what the hell I'm talking about. Even though I don't always get it right, I do my best to try and do that. Let's see, Mario. I did 11 years of a 7 to 14-year state sentence, conspiracy to commit homicide. I was facing 20 to 40 if I didn't take the plea here in Pennsylvania. It's, each case is different. Each case is different. When you, let's see here, Senor Reich, at the quinceañera, I'm originally from South Texas and have only been to one. Yeah. I got one the other day. It was a client that we had in federal court, had a good result, and his daughter was having a quinceañera, but I didn't get the invitation in time. But it was a fancy invitation. I was very, very impressed. It was just very nice, and I probably would have swung by and said hi. Things do the hypothetical need to be rational and logical? Gee, some of these questions are hilarious, Eric. Crystal, do the hypotheticals need to be rational and logical? I'm not sure which one you're thinking. The ones that I've heard, and like I said, I'm not going to say I've heard every hypothetical asked, but they're basing that on something. They're not just making it up out of, thin air. There's usually, he seems to be asking these things from these training manuals, whether it be from the Minneapolis police or the national training standards for the police. And, most of this stuff is, it's obviously written in favor of the police officers. So I don't think any of his questions are been that far out, but if you got a specific example, let me know. Can you give us a funny story, kind of like your criminal of the week? We need a funny moments from court series. Oh, yeah. Let me think about that, Sarah. There's some stuff that is just, it's kind of like the dumb criminal of the day. You just cannot make this stuff up. Things that you see, go on. Sometimes things witnesses do. It's just unbelievable. Some of the stories. I've had, jurors come and say after a verdict, hey, can I hire you? I got a case. Of course, they never disclosed that they had a case going on. Maybe it wouldn't have been, they didn't do anything wrong. Apparently nobody asked. Okay, true crime nut. Scott, can you go over again exactly what you're supposed to do if you get pulled over? Provide your driver's license, registration, proof of insurance. And be polite. Be polite, okay? Common sense prevails. If somebody treats you with dignity and respect, you'll probably do the same. If you treat them with dignity and respect, they'll do the same. Now, let's face it. Sometimes, maybe cops having a bad day. Not condoning that whatsoever, But that's the reality of it. They can do that. Everybody has a bad day. We've all snapped at people. I've had district attorneys over the years, they're just rude to me. And I literally have to ask them and say, I'm sorry, have I done something to offend you? Because if I did, I'd like to know so I can maybe apologize, but I don't think we've done anything. And then they tell you, well, it's not you, it's just, I don't like your client. Well, okay. But you don't have to like my client. I don't have to like my client. My job is to do my best job for my client. So let's get by that. But if you get pulled over, comply. Even if you think it's a BS stop, comply. Ask what you're getting pulled over for. And then ask, once that is resolved, I pulled you over for, what did I do, officer? Never admit. When they ask you, why did you get pulled over? No, I don't know why you pulled me over, officer. Don't admit to that. You're making admissions. Have them explain why they pulled you over. Hopefully they have a body cam on. That's the best thing. I've had lots of clients turn on the recording on their phone. Sometimes cops get offended. I don't know why the police would get offended if they're being recorded, if they're doing everything that they're supposed to do correctly, right? Like, if they have cameras in the courtroom, would I mind? No. Why? I'm doing the best I can. Will mistakes be made? Sure. Would you wish you maybe asked a question differently? Of course. Every case is like that. But that's just the way it is. But nobody should get offended. So if you get pulled over, have your stuff handy, your license, registration, pull over. Don't agree with the officer that you got pulled over. Just say, oh, I wasn't aware of that. When the basis of that contact is over, your officer, may I be free to go? If they say, step out of the car, and you say, why am I stepping out of the car? If he says step out of the car, just step out of the car. Don't drive away. Don't pull a gun. Don't resist. It's only going to go bad from there for everybody. If you think it's an illegal contact and arrest, you fight it in court with an attorney. You don't fight it on the street, right? That's what's supposed to separate us from, caveman days kind of stuff, right? It was all about the strongest, who could survive, strongest to the fittest, all that kind of stuff. We're supposed to be a little more civilized. We take our disputes to the courtroom. We don't duke it out on the side of the road, so to speak. So that's the biggest thing. Let's see. I don't know where the prosecution, this is a Navy vet. I don't know where the prosecution got their cardiologist, but a 90% blockage alone can kill you. Floyd had 3 blockages plus drug use. And that was my recollection of the testimony from the coroner as well. And let's see. Nana, be yourself. Shout out to your 2 mods, Scott. They're doing great. All right. I appreciate the mods. We appreciate them. Don't fight with the mods. And let's think, I'm all about free speech, but you got to keep it kind of, if you want to criticize, hey, Scott's the biggest jerk around, that's fine. I don't care. You're not going to bruise my, leave me any bruises on my ego or my skin, so to speak. But be respectful of other people. Don't call other people stupid. That's just, come on, right? We're adults here. We should be able to engage in an intellectual debate, not by calling people stupid, not by calling somebody a racist, right? That is usually the key indication when somebody begins their argument with a name, accusing somebody of saying, oh, you're just racist. It's supposed to shut it down, but it usually means you have no argument to present. And yes, are there racists in the world? Yes, there are. But the reality of it is just be respectful, be polite, be nice to the mods. I don't think they go around particularly trying to harass people. I really don't think they do. Some people complain. I got an email the other day. But the reality of it is, it's like sometimes you got to work to get disqualified from the chats. Just be nice. And if they put you in timeout, remember what put you in timeout and go there. Like, I'm all about free speech, okay? But keep it nice, okay? You can say, hey, Scott's the biggest, idiot. This channel sucks. You don't know what you're talking about. I love it when, oh my God, Scott, you're rooting for Chauvin. No, I'm not. I'm just trying to explain that they've had a couple of good days. Oh, you must be a racist. You're supporting Chauvin. No, I'm not. And then they're like, no, you are. And then I said, the case, Ahmed Arbery, people are like, I've like the guys in that case that are charged, I mean, they were completely wrong. The law is not on their side. They had no reason to go even come up to Ahmed Arbery. And then I get, other people saying, oh my God, Scott, how can you support? He was breaking into a house. Just even if you thought, and there's no evidence that he was, right? He didn't steal anything. You can't go up with a shotgun and, basically attack people when no crime has been committed and then shoot them. That's called murder. Okay. So, I get it I'm just trying to call it the way I see it. It's like anything like you do in the law. You give your best advice based upon the information you have, and that advice may change based upon new information. So, yeah, I mean, like I said, it's a tragedy for George Floyd. I mean, in his family. I mean, I'm hopefully nothing like that ever happens to my family. Couldn't imagine it. But it doesn't, it's the old thing, is it's, awful but lawful, right? Or lawful but unlawful. I mean, it's I don't know. These police cases are so tough because everybody just draws the line in the sand and says every police officer is bad. Every police officer. No, that's not the case. Okay. Just like not everybody accused of a crime is guilty. You have to look at the facts. You have to look at the law, apply the facts to the law and see. Let's see here. I just got bored listening to all the experts as I was. A few witnesses be enough as long as they understand the law. Yeah, like I said, I think it's just I think the prosecution over-tried the case. And, every time the defense got a little something out of them, I don't think it helps them in any way. Scott, can you answer Jerome Johnson's super chat case about a cold case? I don't remember seeing that chat, but let me go back and see if I can find it. There's so many Jerome Johnson. Let's see if I can find it here. Sorry. Manuel. I went back all the way to the top. That's all I see. I'm sorry. I don't see it. Nana? Because I stay up. Sorry, I don't see any question about a cold case. Do you all see one?
I think it was
Kristen Smart. 1996.
Student, yeah, 1996. Charged someone today.
I will have to. Let's see if I remember this case. The name sounds familiar. Okay, yeah, she disappeared. I remember that. Let's see here. God, I remember that case. That was a big deal. It disappeared 25 years ago. Let's see. They correct a man connected with 1990 disappearance of college student Kristen Smart. Paul Flores, given the presumption of innocence.
No bail.
Bail set at 0. She was going to Polytechnical State University in San Luis Obispo. Disappeared after going to a party. Flores was Smart's friend. Reportedly walked her home from the party. Dad, who's 80, was charged with accessory after the fact. No one's commenting on the case. Flores was long considered a person of interest. Yeah, I guess we'll have to wait and see what the evidence comes out. Why they were able to now get probable cause after, 25 years or something here? Yeah, so I'll have to take a look at that. Wasn't even aware that had taken place until just a minute ago. I know that case pops up quite a bit through the years. Let's see here. Okay. Yeah, so Paul Flores and his father, the father who's 80 was charged with accessory. So apparently they must have something, something. That's the thing about cold cases. If there's physical evidence, it'll come out. But somewhere, someone knows something, and someone probably said something, and there you go. Glad it worked out for them. All right. We are going to wrap it up. If you're not a Patreon member, you should be so, because we're going to continue this conversation on our Patreon page. We'll send a link out to everybody. And on Patreon, we get the bonus. You can actually call in. We can talk. And that's right, the Magic 8 Ball. Last week, we forgot the Magic 8 Ball. Now I have the Magic 8 Ball right in front of me, so we'll not forget the Magic 8 Ball. All right. Thanks for watching. I appreciate you all. I truly do. Be patient. I'm in trial, so I'll try to get a video up, or maybe we'll do a quick live or something, even if it's from my house. We'll try to do something this week about cases as things come up. But if I don't, remember, I'm in trial. So it's not that I'm not thinking about doing something for y'all, but I got to focus on that trial. Just like if you were my client, you want me to focus on that. So, all right. Have a wonderful evening. We'll see all our Patreon members there in about 5 or 10 minutes or less. Have a great evening. Thanks for watching Crime Talk.